helpful to us, and to be broadcasting out over a webinar. It was very kind of them to do so, and on pretty short notice, so that's really excellent. I was asked to introduce both myself and Art, which is a little daunting because there is a slight discrepancy between our experience and our accomplishments. I sort of thought it's a bit like putting Burnaby Mountain next to Mount Everest, and you'll soon see which of the two of us is Mount Everest. I'm a policy lawyer at the Law Society of BC. My job is mostly to assist the benchers in developing strategic and regulatory policy for the organization, with a particular focus on access to justice and access to legal services, and I've worked in that role since about 2006. That's Burnaby Mountain. So Art Vertlieb QC is the president of the Law Society for 2013, and he's been introduced at a range of various events over the course of a long and illustrious career. On our Law Society website, we have bios for all the benchers, and you can get a sense of what Art's done up there, but I get the feeling if we posted everything he'd done, our servers would probably crash because it's pretty accomplished. Art was one of the founders of Trial Lawyers Association of British Columbia, as well as the Lawyers Assistance Program, which has grown into really being one of the leading programs of that sort in British Columbia and North America. And those would be amazing accomplishments in and of themselves, but Art, of course, has done more than that. His work with the Law Society, I believe it came about prior to becoming a bencher. He'd done some volunteer work as a lawyer, as lawyers often do, and then was speaking with former bencher Jim Bilvang, who encouraged him to run for bencher, and Art did so, and we're fortunate that he did. And in 2004, Art was elected as a bencher to the Law Society. Since that time, he's been involved in virtually every kind of committee, task force, and working group that you can imagine, and has chaired many of them. As president, he is the chair of the executive committee. He's also the chair of the governance committee, which the benchers are doing to review the governance process for the benchers, the appointment subcommittee. Prior to that, Art was chair of finance. He was also chair of the discipline committee, and the discipline committee is an absolutely core regulatory committee for the Law Society. And anyone who gets involved in that, and I think particularly chairs it, gets a real understanding of some of the core public protection roles that the Law Society does in terms of processing complaints. On a policy end, Art, and this is where we first met, was chair of the Equity and Diversity Committee. That really exposes the participants to some of the barriers and challenges that individuals and minority groups in our society face, both in terms of participating in the legal profession and in the justice system. And I think it gives everyone who participates a real grounding in some of the challenges that people face. From that, Art and I worked together in the Access to Legal Services Advisory Committee. Art chaired that for a year. And he was also chair of the Delivery of Legal Services Task Force, and that is the group that led to the reforms which we'll be talking about in a little bit more detail today. Art has been the recipient of the George Goyer Award for his contributions to the legal community in British Columbia, and more recently the gold medal, the Queen Elizabeth Diamond Jubilee Medal. I was trying to think of what he hasn't done. I don't think that he ever in his goaltending career led the Habs to a Stanley Cup, but that's probably about the extent of it. Art's a real pleasure to work with, and one of the reasons is the benchers at the table all bring different strengths, and one of the things that I always quite admire about Art is Art likes to find solutions to problems in the community and problems people face, and he locks in on practical ways of doing that, and that's always what he's trying to drive towards, is practical and principled ways to do it. And I think this program was a really good example of how the Law Society was facing an access problem and had some ways of finding solutions rather than finding reasons why you don't advance change. And Art was a real champion for that. And one of the things I can say is there was no slam dunk along the way as this was being developed. Certainly when we were dealing with the courts, there was some resistance to an expanded role. Understandably, courts have to be conservative about reforms to the system. And I would say that but for the work of Art and our past president, Gavin Hume, QC, to kind of make this project their own and champion it, we probably wouldn't be here talking to you today. So Art, thanks very much for that, and over to you.
Well, Doug, I do want to tell you that there are many things I haven't done, and one thing for sure I haven't done is any male modeling. I want to be real clear about that. But Doug, you mentioned Burnaby Mountain and Mount Everest. No one ever climbs any mountain alone, let alone Mount Everest. And I just want to say that the policy people at our Law Society are the ones who really are the troops on the ground. We as elected benchers have, input on policy and ideas, and we meet and are committed to change. But it's people like Doug who bring their brains and their energy to a project, and the two of us have worked together now since 2008 on this because we both share the same commitment to try to find ways to make access better. One of the drivers for both of us that's interesting is that Doug had been a paralegal before he became a lawyer. And for most of my practicing life, I've worked with paralegals that have embraced the skill and ability that people who are paralegals bring to our clients. And so I've always been a very big believer in the merit and the great benefit of working with very smart people who are paralegals because they add so much. So the idea of expanding the role of paralegals in British Columbia was one that both of us embraced out of a strong personal conviction, and it made us, I think, that much more effective in working together with the help of many people. Doug and I have decided today, in the way we think might be most helpful, knowing that there will be questions, we want to keep our comments very brief because we're really committed to being able to answer questions that people will have. One thing that we want you to keep in mind is that Doug prepared a worksheet on designated paralegals that Rose has circulated to everybody in the association, and it really sets out in a wonderfully concise but very complete way what we've tried to bring into place with this expansion of the paralegal program. So that being said, let me just say to you in a big picture way, what we really recognized at the Law Society is that there's serious issues around access to justice in this province, and we're not alone. Anywhere in the Western world, any Commonwealth country is now talking about access as a major issue. It's not just in British Columbia, it's not just in Canada, it's not just in North America, it's throughout Asia and throughout Europe, wherever you have common law jurisdictions. And no one has the answer to fix the access problem. And so what we tried to do at the Law Society is take some steps that we knew might make a difference. And allowing our paralegals an enhanced role won't change the universe in this province on access, but we believe it will help. The reason we're here today is it became obvious to us that even though we've talked a lot about paralegals and the changes, we realize that many people in the Paralegal Association may not fully understand what this is about. Not only is it in the paralegal world that there's perhaps not a full appreciation, but in the lawyer world there isn't either. And so what we're committed to do this year at the Law Society is go to groups such as this group and go to groups in the legal community and talk to them about what we're trying to do. The essence of all of this is that anyone who has skills that are skills that a lawyer is prepared to say you have the ability to be designated can be a designated paralegal. There's no magic to it. It's a matter of what you've either studied or learned empirically, or obviously a combination of both. Our program is the lawyer-supervised model because we knew if we wanted to bring in a registration model, some kind of credential model, we would be years in the development. And we made the policy decision that we had to deal with access now, and recognizing that over time we will probably end up in a system where paralegals will be credentialed and inevitably, in my own view, ultimately become members of the Law Society. I believe long-term, the people with the skill sets in this room will ultimately be members of the Law Society of British Columbia. Many of you know that in Ontario, the paralegals have been independent for many years, and they have benchers at the Law Society. They're fully involved in the government of the legal profession, and they're fully embraced. In our view, that will be the ultimate result down the road. But sitting back and trying to develop a system of registration, credentialing, whatever you want to call it, we knew would take years to develop, and we just wanted to get this project up and running. And that was the way and the reason we went to a supervised model. It's all about the trust of the lawyer and the paralegal. So in our firm, we have 2 designated paralegals, and our firm, as you know, doesn't do any legal work in the family area. So I've actually had paralegals say to me, why would you have people designated when you're not doing family work? Well, the reality is we have designated two of our people who we know are very smart, and they're very seasoned, and we trust their judgment, and we have confidence that they can give clients legal advice. That's the core of the program. What we're saying to people who have the skill is judged by the lawyer who will be responsible to the Law Society. That lawyer says, I have the confidence in this person to give our clients legal advice. So in our firm, both of our designated paralegals can meet with clients, give legal advice, send letters giving legal advice, and there's no subterfuge in any of that. For years, firms have used paralegals to do legal work, but there was a legal prohibition about these people actually giving advice. We have it out in the open in a very transparent way. And every area of law can have a designated paralegal. All that's happened on the pilot project side, where paralegals are now authorized to go to court, is that for the pilot project, it's been restricted to family law. So think of all the areas of law that paralegals work in and realize now how suddenly the future has opened up wide. You're doing corporate work, you can now meet with a corporate client. You can tell them what the Act says. You can tell them what the legal requirements are for filing. You can send letters. You can send bills. You can do everything the lawyer does, provided the lawyer says, I will supervise you and be responsible for your work. Tax, immigration, real estate, all the areas of law are open to people being designated. The only small area where there's any technical issue is on going to court, which right now is restricted to family law. The restriction we know is one that will impact on the number of paralegals who are designated and are going to court. But it became the best way to start with the process to at least get people understanding the idea of having a paralegal in the courtroom. Because judges, understandably, weren't sure about it. They understand lawyers who are trained and officers of the court, but having a paralegal stand and make a submission is something that judges have never seen. Luckily for us in this province, we had Chief Justice Bowman and Chief Judge Crabtree, who were believers in the idea of taking creative steps and progressive steps to make a difference. And those two chiefs supported our Law Society initiative, and that's why we've been able to crack through what would have been a barrier. So that's what I wanted to say by way of an opening comment to give it the big picture understanding. Everybody in this room, if you have skill in an area and your lawyer that you work with recognizes that, can be designated. It's between the paralegal and the lawyer, and it's a trust system that we rely on. So each and every one of you now has opportunity before you that did not exist prior to this change last year. Now, Doug is going to give you some of the specifics. Doug knows the technical side of this better than anyone in the province, and he will highlight some of the technical changes, and then perhaps with Rose's help, we can take some questions.
Great. Thanks, Art. Some of what I'll say will echo the information that Art has already given you. What I'd start with is to also say, obviously, you've got the document that Rose has distributed to you. On the Law Society website, into the area for lawyers, and you go down, you'll find a link for paralegals. That'll give you some more detail about the program. It'll flesh it out. It'll have all the particular types of appearances in family law you can make, and just really give you a breakdown of that. If at the end of today, plus reviewing those materials, you still have questions, you can certainly feel free to contact me at the Law Society. And to the extent they might get into real practice questions for your lawyer, our practice advisors are also available to them to answer questions that they might have about the practical mechanics of the work going forward. As Art said, we locked in on a lawyer supervision model, and everything he said is exactly why we did it. The Legal Profession Act doesn't give us the authority to directly credential paralegals, and the process of reforming legislation requires you to approach government, make the case for it, and that takes time. So the timing issues are critical. We wanted to get something done. And we started in 2008, and here we are today with it launching. So that gives you a sense of almost a fast track. And you can imagine that once you have to engage other people and seek their permissions, it slows it all down. It's not to say that down the road we might not get into the credentialing as Art has forecasted, but we wanted to have something hitting the ground. So when the task force looked through it, what they realized, amongst other things, is right now we've got the BC Code of Conduct. It's come into effect as of January 1 of this year. The purpose of that code is to sort of have a harmonized code across the country. The Federation of Law Societies was driving that. There's some variation between provinces. For example, we have designated paralegals in BC. They don't have them in other provinces. But for the most part, it's looking for a harmonious approach to professional conduct. In the past, though, we had the Professional Conduct Handbook, and there was no definition, as you probably all know, of paralegal in that. There was legal assistant. And as you're probably also very clearly aware, there are many people in British Columbia working at a law firm who are called paralegal, and their background and experience can be incredibly varied. And so for members of the public, that obviously creates some challenges in terms of knowing when you're dealing with a paralegal, who am I dealing with? What are their credentials? What is their background and criteria? So the model we tried to build was one that first got a definition of paralegal, and then because we were adding something new, that would be allowing the paralegals to give legal advice and appear in court, we needed to come up with a type of paralegal that was going to be allowed to do these new additional types of things, and we came up with a designated paralegal model. And our ethics committee worked through the language of that and put it into the model code. And so if you look on the Law Society website, in the BC Code, under Section 6, you're going to find those definition breakdown. And the paralegal is essentially a non-lawyer working under the supervision of a lawyer. But the designated paralegal, as Art hit it on the head, is someone that the lawyer has said, you have the capacity to do these additional things. You can give legal advice and you can appear in court. And in Appendix E, we've set out some guidelines and criteria, both for supervision on the lawyer's part, but also to say, here's some filtering criteria that lawyers should engage in when they're making that decision as to designate someone or not. Because there's obviously a due diligence component of it, a best practice when you're working through that with your lawyer would be to create kind of a document of it. Here's what the steps we went through to designate you. It's not to say something will go wrong, but if there were a complaint down the road and the lawyer was called upon by the Law Society to sort of explain what happened in the file, one of the questions you might imagine would be, well, how did you come about designating this individual as a paralegal? And so to have that evidence trail in place is probably a good practice to do. There's no magic formula to the designating process. You can end up with someone who has many, many years of experience and knows their discrete area of law inside out. In England, they have legal executives who are essentially lawyers that have a really targeted area of practice. In a way, the designated paralegal can kind of function in a similar way here. You just built up that specialty. Other people may have graduated from an acknowledged program that the BC Paralegal Association looks at to its membership and being part of. But even there, the lawyer is going to want to engage in some practical assessment of, well, what skills do you add to that on a case-by-case basis? So lawyer designates someone as a designated paralegal. That creates the potential for that paralegal to give legal advice or appear in court, but there's still got to be an intake and a triage process. It's not like all of a sudden there's an associate lawyer who's in the firm, who's opening up their own files, getting their own clients, and acting in isolation of the other lawyers there. They're still going to be under the supervision of the lawyer. When the client file comes in, it's still a solicitor and client relationship between that lawyer and that client. What the lawyer has done is said, this matter is appropriate to be delegated to the paralegal, the designated paralegal, and they've asked the client, I've got a designated paralegal, here they are. I believe that they're competent to help you in this. You're going to realize a cost savings through doing that. And the client says, yes, I'm interested in that. And hopefully, if you have a retainer agreement, it gets memorialized in that. And then the designated paralegal is going to carry out their work. Supervision is a big part of all of this because at the end of the day, the lawyer is the one who's going to be accountable and responsible for what's going on. We don't have a direct mechanism, as Art said, to discipline paralegals. So it has to happen through the lawyer process. And because we had decided that we were expanding what paralegals could do to include essentially almost everything the lawyer could do when you get down to the giving legal advice, there's a bigger risk window, theoretically, that opens up there. And so the same level of discipline processes will exist in the circumstance if something happens with the paralegal as if it was a lawyer who was doing that. And so the lawyer needs to be aware of that. What all of that really speaks to, I'm not saying that to cast fear into anyone's heart, is that you have to actually have meaningful supervision. You have to have dialogue with the lawyer. So there's the intake process that you have to have, but you'll figure out, and it'll vary based on experience and time, and as you go further and further with your designated paralegal and build that relationship, maybe it starts with once a week you have a file triage. Where are things at with these files? You touch base on stuff. You always should have the open door policy that if the paralegal starts to feel, I'm not feeling comfortable with this, or something that seems out of the ordinary, they should go and talk to the lawyer, because it may be the case that the lawyer needs to step in. Certainly if the paralegal ever makes a mistake that might cross that threshold in terms of negligence, they've got to tell the lawyer right away, and the lawyer's going to have to look in there and do a triage, because the lawyer has reporting obligations both to the lawyer insurance fund and has that relationship with the client. So you have to work that into your network of approach. So what we did and what the task force did, and there was a real debate here as to how do we maximize this program while at the same time protecting the public. And so the issue of capping the number of designated paralegals came up. And the delivery task force sort of had two groups. The group that sort of won the day, because it was slightly into the majority, said, let's take a measured approach. Let's put in a cap, and we'll limit it to 2 designated paralegals that a lawyer can supervise. 2 is the same amount of articled students that a lawyer could supervise, and that was part of the reasoning. And it was just a cautious approach that they wanted to take to that. The other group thought it should be sort of wide open because we want to maximize the access to legal services benefit. So what the benchers adopted was a cap of 2 for designated paralegals, and that will be reviewed at the end of a 2-year process, and we'll see how things went from a regulatory process. Were there any concerns with this? Should it be expanded? Should it be maintained or changed in any way? Now, it's important to be clear on that the cap relates to designated paralegals. It doesn't relate to paralegals. So if there is a lawyer out there who is supervising 5 paralegals in a conveyancing firm, and they have no intention of designating the paralegal, they're still supervising 5. It's only if they're allowing that paralegal to give legal advice or appear in court that the cap model kicks in there. Again, as I said, it's still going to be the solicitor and client relationship that's going to govern it. So legal advice, as Art said, it's not limited to any particular area of law, and it's also not geographically limited. And I'll get to the family law component, which is, I think, and I think Art shares this view, that that is the big game changer in all of this, because it allows a client on an appropriate file to be talking to a designated paralegal who can essentially run that file at a lower cost than the lawyer could. And it can either do one of 2 things: bring some people in the door who otherwise might never approach the lawyer because of a cost relation, or in a model where the lawyer is going to do some of the work and the designated paralegal is going to do some of the work, maybe almost sort of in an unbundled model. It's going to make their money go further and reduce the likelihood that somewhere down the road the client runs out of money in the middle of a retainer, and that's to no one's benefit when that scenario unfolds. So it's a big change. The family law component of it, again, as Art said, is a discrete one. And the reason for that, the Law Society has said that you can appear as a designated paralegal before court or before a tribunal on the terms that the court or tribunal permit. We haven't gone out to individual tribunals, but it would be open to any tribunal to allow a designated paralegal to appear before them now on the terms and conditions that that tribunal said. We've cleared it on our end, and if a tribunal is going to clear it, that's fine. With the courts control their own right of appearance, and it's important that they do so. And so we had to enter into a dialogue with them to say, from a Law Society perspective, we feel comfortable with this project, but what are you as the courts prepared to entertain? And initially, as Art had said, there was a bit of resistance to the concept generally. And so through a dialogue, they said, well, let's try a pilot project, and let's try and lock it into an area of particular need, that being family law. And in addition to that, we want to test it in a couple registries. So the BC Supreme Court has agreed to run the pilot project for 2 years. It started as of January this year. It's going to be in Vancouver, New Westminster, and the Kamloops Registry. And in the provincial court, it's taking place in Surrey, but also in the Cariboo Northeast District, which is obviously a bigger area. And the provincial court said they weren't entirely sure how that one's going to play out, but they wanted to test the access question on a broader area. On the website, there's a table of all the types of appearances that a designated paralegal can do in family law. That table was put together through the work of our Family Law Task Force. That consists of a number of very senior benchers with extensive family law experience. And what they did was they went through the rules and what used to be the Family Relations Act, because we didn't have the new act in place at that time, and said, what do we think are the appropriate types of appearances for a designated paralegal to make? And they really honed in on largely procedural, what were classified as non-contentious procedural applications, but a couple applications that could be contentious as well. Then we dialogued with the court. And what I think we all probably found a little surprising, certainly with the Supreme Court when we went, we gave them the list, and they said, okay, well, we're concerned about this, remove this, but did you think about adding these other things? And we said, well, no, but if you're happy to add them, that's great. And so the court came back and had some things to add. And so it got a little bigger than we'd initially said. And so the process, which at the front end seemed to have some resistance, grew a little bit, which was excellent from our perspective. And so that's the model that's been set out and that's in place. What the courts will do is they're going to run their own evaluation of it. The provincial court has provided the Law Society with a form, an evaluation form. It's available on our website. And so at each appearance, the paralegal should be bringing in that form. And what you'll see is that the top half you fill out, and the bottom half is for the court to fill out. And it essentially is going to say, here's how you did from a competency perspective. And at the end of the 2 years, we'll evaluate that. Supreme Court's working on their evaluation form right now. What also you'll see in there is that there's an affidavit from the lawyer that's going to be filed in the first instance. But if you're doing repeat appearances on the file, you should probably bring a copy with that around. And really, that's just setting out, I am the designated paralegal of lawyer X. They've authorized me to make this appearance, and so on and so forth, so that there's no ambiguity as to that. So that's sort of that. What we also have is a change, and it isn't a change that comes from the delivery task force. This is a change from the model code harmonization that I was talking about, and that's with respect to undertakings. When the task force originally looked at undertakings, they had sort of thought, we're not going to say that designated paralegals can give or receive undertakings. But the ethics committee, because in other provinces non-lawyers can do it, said we have to work towards this harmonization in the code. They're going to be able to do it. And so the benchers put that in there. And what you'll see in the code, and I think it's in section 6 of the code, there's a basic, it's a negative rule. So what it says is a non-lawyer cannot give or receive an undertaking unless. And then it sets the conditions on which you can. And the essential nature of that is obviously that the lawyer's supervising you so that they're aware that you're going to be giving undertakings on a particular matter, that the role of the non-lawyer and the capacity of the non-lawyer is disclosed to the person so that there's no ambiguity as to who they're dealing with. And the lawyer is going to be held accountable for that undertaking that's given. So again, this goes back to supervision in an open door policy. And from one matter to another matter, it may be appropriate. And the lawyer says, yeah, it's fine on this file, or no, it's not fine on the other one. The last thing I think that I would add in there is, well, two things. One, trust accounting. Lawyer's still responsible for all the accounting. It's the lawyer's trust account. They're the one who's dealing with checks and the processing there because they're the one that gets audited by the Law Society. And lastly, that the Law Society, probably midway through this year, we're going to update our annual practice declaration, and we're going to have some stuff in there that when the lawyer is filling out their annual practice declaration, there's going to be a little section that says, do you use designated paralegals, yes or no? And if the answer is yes, it'll say something to the effect of, do you supervise one or two? Click. Areas, so on and so forth. And that'll give us something that we can look back on, both to get a sense over time of what was the uptake on this, but also if there were particular complaints that came into the Law Society flowing from that, that we could match it up and say, from a regulatory perspective, was there anything unforeseen consequences that we just didn't see happening, where we need to maybe change our rules or update our processes to make sure the public is best protected. So that's the program in a nutshell, and I don't know if you have anything you want to say in terms of to add to that or going forward, or just open it to questions.
No, Doug, that's very, very thorough, and we're happy to take questions. Rose will take questions off the internet, and anybody in the room, obviously. There must be some questions because
So, Art, I do have some questions online here.
Okay.
Got Claudia. She's asked, are paralegals permitted to notarize documents, i.e. statutory declarations, affidavits, certified true copies?
Well, it's interesting that that question's asked, not because you're designated, but there's an application process that two of our two designated paralegals just went through, and just in the last week we're given permission to notarize documents. And that's Marianne and Deborah who've done it, and they know the whole procedure to do it. So that's the answer. The answer is yes, but there's got to be, it's a matter of filling in forms and getting certification.
Okay, so it's Rose here, so I'll talk to Marianne, and if there's any members that need to know the process for that, they can contact me directly for that. We've got another question here from Diane. And Abigail, I think they're similar questions. Diane's asked, is it conceived that designated paralegals maintain that designation even after the lawyer-paralegal relationship ends, or would the paralegal be formally designated until they find another designated lawyer?
Yeah, the process there, because we are dealing with lawyer supervision and it's about the public having an understanding of who you're dealing with, you are designated for the purposes that a lawyer has designated you to. So again, I have a paralegal working for me, I designate them. Maybe I have a general practice, and I say, this paralegal is exceptional in family law. And so I'm going to designate them to be able to do additional things in family law, but they're not at the spot I want them to be for some of these other areas. They might not get there. It's not a uniform license to give legal advice in all these areas. It is contingent on that relationship. And so what I would say is if you go and find another job, say, or if your employment was terminated for whatever particular reason, you had been a designated paralegal, and so in terms of when you're trying to deal with your new employer, you could say, I was a designated paralegal at this last firm, I'd like to explore that possibility with you. That new lawyer now has to go through a process of determining, A, am I comfortable with doing that? And in our guidelines, what we've said, amongst other things, is in circumstances like that, contact the prior lawyer. You go through a discussion, what was the work like, so on and so forth. They may still want to take a bit of time before they have that comfort level of saying, I'm prepared to allow you to give legal advice or appear in court, because again, the responsibility rests on them. But it's not a certificate that is then carried forward as a universal license to do something.
Great, thanks, Doug.
Now, someone here in the room had a question, Rose.
Oh, okay. I had a question. If you become a designated paralegal, do you need to have that title on any electronic signatures when you sign a letter, or is it something that you can keep your title as a paralegal, or does it need to be designated paralegal?
There's no requirement, because again, we don't directly regulate paralegals, of saying how you need to market that. I think that would be a choice for the lawyer to make. And what you just want to be clear is the capacity in which the individual in any particular matter is working through. There may be some advantages on a case-by-case basis of saying, I want to have this designation because it is a form of distinguishing you, hopefully, from someone who's calling themselves a paralegal who maybe is just, the lawyer's nephew who's working for the summer and that comes in and says, well, I need a paralegal, and that's what, you don't turn your mind to what does that really mean. This requires the lawyer to turn their mind to what does it mean to call you a designated paralegal, but there's no requirement.
But I would think that if you're designated, you'd want to have that all the time, just the way the lawyer would always say, I'm the lawyer, as opposed to being silent on it.
And even just for the public that may be using it, you can search up the definition of a designated paralegal, but you can't for a paralegal, right? So you should maybe do that.
Yeah, so the observation there was that using that designation, it gives the public who are doing any kind of an internet-based search a little bit of more precise information to know who they're dealing with.
On the point, it's really important that the paralegals are pushing their lawyers to get into this discussion. And it's equally important for the lawyers to be dealing with their paralegals to have this discussion. Because if we don't raise the awareness in our profession, we're going to have a difficult time making a difference. The more we talk about it and the more people see that word designated in front of paralegal, the more members of our community will start saying, well, I want to have someone who can bring this service, but it'll be a lower cost. And so that's principally why we are so committed to being out and having sessions like this and traveling around our province and talking to lawyers. And so the more people that become designated and indicate that, the better. When Mary Ann Reinhardt writes a letter saying designated paralegal to an insurance company, they probably the first time wouldn't know what that meant. And so we want people in the industry to say, well, what is that? I saw that on your name. And then Mary Ann can say, I do this and I do that. This is new ground, but it's important new ground. And it's really, this program's only going to make a difference in terms of getting access to justice for people who are struggling to get it, if people know about it.
I think Art has just really hit on a critical point there from a regulatory perspective. As a regulator, a law society in this case with access to justice, we're stuck with trying to figure out, are there barriers that we can remove that our rules are creating, or are there rules that we need to put in place to better protect the public? And it's a tension between the two. But we can't create markets. We can't create business models for people. It's the lawyers and the designated paralegals working hand in hand that have to make those happen.
Any other questions? Because there's something I was going to indicate to the group. Rose, do you have something else
I
there?
do have some questions. Just one second. So we've got a question from Diane. And her question is, how heavily weighted in the decision being made to designate a paralegal is formal post-secondary education?
It's a really good question. I think the answer is that it becomes a collection of discussion points. So Mary Ann, for example, has a Capilano program that she's completed. I know the Capilano program because years ago one of our people became the person who started that program. And so I've always had a particular affection for Capilano's program because I've lived with it for so many years. So I know what that program does. There are other programs in this country that are very good. I happen to know Capilano, so I didn't have to go through what that course taught. If someone came in with a program from Ontario, I would want to sit down with this paralegal and say, well, show me what the program covered. What did you learn? I'd want to know what the knowledge base was. And I was thinking about the question, actually. So what if the person fresh out of Capilano comes to our office and says to me, I want to be designated? I'm not going to do that. No, it's no different than a person fresh out of law school. And we don't put them into a courtroom on their own. We call them articling students. The theory being that they spend a year learning a lot about the way the profession works. So I would want to have some experience-based work as well. But there's no scale. It's not like getting a dozen eggs in a box. It's not like buying a kilogram of oranges. It's a matter of sitting down as the lawyer and deciding whether that person has the skills that you're going to put your name behind. Remember, I'm the one, as the lawyer, who's going to wear the problem. So you can bet I'm going to be sure, and my colleagues are going to be sure, that they're confident in the skill set of someone that we say is now designated. And that's going to be a collection. It might be a few years, it might be 1 year, it might be 15 years. Frankly, you should also recognize you don't have to have gone to Capilano. We specifically recognize there will be people who have done this work for 20 years and went to a little secretarial course following high school, but know every aspect of a motor vehicle lawsuit. And we recognize that if we started to prevent people with hard experience, that we would not be meeting the goal of access. So it's really a very flexible test that's based on common sense. Is that person someone that you feel could give legal advice? And on that, I'll tell you what I, like yesterday with Mary Ann, we sat through 2 new client interviews, and I have Mary Ann, who works with me, sit in on every new client interview. And I introduce our designated paralegal to the client and say, this is what that means. It's a special designation, and it allows people to give legal advice. It's very important. But I would, in the course of the discussion yesterday, I couldn't help but think of it. I said to Mary Ann, what do you think? So she's involved at the beginning, and that's how I know she's alive to what's going on in the case. And so that's how we have worked it. That's not the rule. That's the way I know we're getting the level of experience and input and insight that makes me comfortable allowing Marianne to then do all the things that need to be done. The key in all this is there's so many people who have skills that heretofore have not been able to openly use those. You're at a frontier. This is like Lewis and Clark when they discovered the Wild West. You're at the cutting edge of new developments in law that are going to bring a tremendous dimension to the work that you do. It'll bring personal value to who you are, and all of that should result in a benefit to the people of our province who legitimately are having issues getting advice from people who know what they're doing. And so if you keep that in mind, each of you in this room could go back to your office and say to the lawyer you work with, why can't we discuss being designated? And those of you in the room who know that would work, you know exactly who I'm talking about. Now, Rose, I hope I've answered that question because it's a fair question. It's not it's a collective decision. Doug makes a very good point, though. You should document it so that if someone from the Law Society wrote and said, why did you designate Bill or Jane or whatever, you've got it memorialized. Here's the decision-making process. So I wouldn't designate someone who had arrived in the office on Monday and say, oh, yeah, Tuesday, you're fine. I'd want to work with that person to make sure I trusted their judgment.
Thank you, Art. I've got a few more questions here. I've got Miriam. She's asked, can a lawyer supervise 2 designated paralegals and 2 articling students at the same time?
Yes.
Great. Thanks.
Don't you love answers like
that? Yeah. It took us 50 minutes to get to the one-word answer, yeah.
Got Nancy here. She says, small claims court seems like a natural fit for the in-court pilot program. Is there any chance the in-court pilot program could see expansion before the end of the 2 years?
That's a terrific comment. We agree completely. Just keep in mind the comments on why we started the pilot project in family the way we did. I think right now we just need to get that going. We need to get people designated. We need to get them designated in all areas of law. We need to have some people going into court on the paralegal side, and all this will develop in time. But there would not be any practical appetite right now for Doug or me to get on the phone to the chief judge and say, hey, why don't we expand this? There's a lot of work to get it to this stage. Realistically, this is going to be the 2-year project. And with any luck, it's going to be expanded greatly. It's a natural for small claims. It's so obvious how people who have the skills in this room could go to court. All they need to do is be taught how to bow to the judge. Truly, because I had to be taught that. I didn't learn that in kindergarten.
That's law school.
Yeah. But, little things like that, how you bow and what you call the other lawyer, where you stand, when you would speak, when you don't speak. But those are all just learning curve issues. There's no magic in it. And so this is going to go. This program has every benefit, and there's not any negative. It's going to happen. We're going to make a difference. It's a question of just how long it takes.
Great. Thanks so much, Art. I've got a few more questions here. I think this one's for you, Doug. This is Douglas. He's asked, could you please clarify about undertakings?
Okay, so the undertaking, the particular provision, I can pull it out here so I have it handy. First off, again, it is part of the BC Code, which is on our website. non-lawyers in other provinces, I believe Ontario, were allowed to give or receive undertakings on certain conditions. And so as the various law societies were working to harmonize a code, that's why it got into the British Columbia situation, because it's happening elsewhere. It is framed, what I said, in a negative. There's a prohibition against giving or receiving undertakings. The general rule is you can't do it. But there's an exception. And the exception requires you to meet the conditions that are listed. And just for absolute clarity for the person, what I will do is I'll read what that is, and hopefully there won't be any ambiguity then in terms of my interpretation of it. So, the negative. A lawyer must not permit a non-lawyer to give or accept undertakings or accept trust conditions, except, and here's obviously where we list the way in which you can, at the direction and under the supervision of a lawyer responsible for the legal matter, providing that in any communications, the fact that the person giving or accepting the undertaking or accepting the trust condition is a non-lawyer, you've got to disclose that, the capacity of the person is indicated and the lawyer who is responsible for the legal matter is identified. So, let's assume I'm a designated paralegal or any other non-lawyer with the undertaking. My name is Doug Munro. I am a paralegal. I am working for so-and-so who is the lawyer on this matter, and you make it clear in that communication. The supervision component obviously involves us having had the discussion that they're okay with me giving or receiving undertakings on a file that they've designated to me to work on or to assist with, because it doesn't have to be a designated paralegal matter. This is a non-lawyer exemption, which includes designated paralegals, it includes paralegals, it includes someone who has an other categorization within that office. And that is in the BC Code, it's Rule 6.1-3 sub C.
Keep in mind that if I take a motor vehicle case, the insurer sends the release to me on an undertaking not to pay out to the client till the release is signed. I couldn't have our designated paralegal send it back to take care of my undertaking. I've still got the undertaking. But what it would allow is in the same case, if the designated paralegal for the insurance company, that person could send the release to me on an undertaking, etc. So it doesn't change the way undertakings work. It just means we've got one more person who can put others on undertakings or accept them if they were put back. But we've talked about this on the way over. One of the things I think you might do initially is have a copy of the letter and have the lawyer just initial it for the file, so you've got that. Because what you really want is to make sure the lawyer you're working with knows the undertaking you're giving. And you want to be fair to the lawyer. Even though the lawyer says, yeah, I trust you on that, I think you should always just say, listen, just so you know, I gave an undertaking on a release or whatever. And document it in the file. The lawyer might not think to do that. I think that would be good practice, and we will be telling lawyers that when we visit with them.
Art's point is great, because when it goes back to what the delivery task force, as I said at the very beginning with undertakings, delivery didn't recommend that undertakings could be given, and the reason why they didn't is because they thought that's a great opportunity to check in with the supervising lawyer along the way on the file about issues. Again, the Ethics Committee and the Law Society to Harmonize the Model Code did that, but it doesn't mean that it's any less of a great opportunity to be checking in as a matter of due diligence.
Great. Thank you both. I've got another question here from Douglas. So he's asked, is there any process to register the designated paralegal at the Law Society?
No, because we don't credential or regulate paralegals. It was one of the things that the task force thought of as an optional thing, whether or not we wanted to do that. The only extent to which we'll have that type of information will be when our annual practice declaration is updated. That'll let us know that individual lawyers are using them, but we won't have the names of the paralegals, because as an organization, and probably for best practices on personal information collection, there's not really the need for us to be collecting that information to that level of specificity. It would only get triggered if a complaint came in.
Great.
Good question. You see, it's important. It highlights the way we're doing this on trust between a person who we designate and the lawyer. But that's what you want to have anyway in the relationship.
Great, thank you. Claudia here just has a comment regarding Nancy's earlier question, and she just says, regarding small claims, and she says the same holds true as well for criminal court and pretrial appearances, i.e. interim and brief appearances, first appearances, and basic adjournment.
Well, she's absolutely right. Part of our program is we went down to meet with 8 criminal court judges at Main Street, and it wasn't an environment where there was embracing of this concept. And I'll leave it at that. So.
Okay, I'm just going through the list here. I think I might have 1 or 2 more questions. So Diane's asked whether the notarization point applies to all paralegals or just designated paralegals.
It wouldn't apply to just designated, because that's our business,
Right.
Law Society. The approach of the documentation is with the governing agency. But all people have to do is get these documents. I was really quite impressed that this change, I think it's terrific for law firms and people, particularly in small firms.
Fantastic.
Where, one firm lawyer, the lawyer's out of town or away, and something needs to be, an affidavit needs to be notarized. I think it's great that we can now let designated paralegals do it. And really, it's a natural for the designated paralegals. They're smart. They know what they're doing. So they can, it's just terrific. You wouldn't want maybe a 6-month person having to do affidavits. They wouldn't know what it's about. But I think it's just all part of change and people recognizing we've got to cut down barriers.
Diane's full of questions today, which is great. So she's asked another question, great question. Can a designated paralegal perform designated paralegal work for more than just the supervising lawyer? For example, in a large firm on multiple files with different counsel.
Yeah, I think you could, but you'd still need a lawyer, be it that particular supervising lawyer, to make the assessment that they have the capacity to work on that particular file, right? So if you're dealing with a larger firm which has different departments and you have designated your paralegal to help in intellectual property matters, and someone with construction says, I want to use the designated paralegal, the construction lawyer, who has the experience and knowledge about construction law in the way the intellectual property lawyer doesn't, is going to have to go through an assessment process and is going to have to be supervising that person because it's understanding the competencies of the individual to the particular file at hand. So I think what you'd have there is a designated paralegal who has 2 supervising lawyers for as long as they happen to be doing work for both those people is how I would view that.
Great.
It's a really good question.
Yeah, it is.
In that situation,
Yep.
where you have 2 lawyers designating one paralegal, that cuts into their ability to designate other paralegals because they each only get 2.
Right.
Yeah, so the question, if anyone didn't hear it, was in that scenario, does it create any kind of a limitation firm-wide, I guess, as to the number of designated paralegals because you have a cap of 2? And in that instance, yes, it would.
That's a happy state to get to. We want to have those problems. That means this program is really up and running.
And it also is the kind of thing that at the end of the 2-year, when we evaluate the cap, what we want to do is, obviously get a collection of lawyers who are using designated paralegals, the more the merrier, and we are going to approach them to see if they will fill out a voluntary survey about their experience, and those types of feedback opportunities will happen. So what I think would be great at the end of it is the lawyers to fill the survey, but to sit down with their designated paralegals and say, how did this work? What changes are there?
Remember,
give that feedback.
It's all about access. And what a wonderful way to help people. So I'm not going to be involved in a small claims case, but we have a case that we took on to help someone who has a medical negligence issue. There's no way I'd ever put any time into it. I just wouldn't do it. And Mary Ann Reinhardt has met this client, and she can manage the filing of the documents for him and tell him what he needs to do. There's an example of someone who have an opportunity to get into court with someone who's making sure the documents are fine and will explain what you need to do and how you're going to need some expert evidence and get that person help they wouldn't otherwise get. It's all about that. That's the core of everything we're trying to do. And I think, again, for the paralegal people, what a wonderful way to meet clients and work with them and be engaged in problem solving. It'll make your lives so much more, it only can make your life more interesting. Because people are in this profession because we want to make a difference. We're in it because we want to help. We like We like being in the service industry. And this is all the more connection you'll have with clients.
Thanks, Art. I've got two more questions here. Stacy asked a question regarding accounts. She says, I was under the impression that only the lawyer could sign the account. This comes from the webinar on BC Code of Conduct. Could you please clarify?
Yeah, I think that would be right. It's the lawyer's trust account. You're not running a separate business. And I think just for our accounting purposes, that would be correct.
And Sandra asks, would the Law Society insurance premiums be increased to accommodate designated paralegal?
We got input from our lawyer insurance group, and they said they were comfortable with the cap of 2, that it wouldn't manifestly increase the risk window, because the issue there, obviously, is we're only collecting fee from the lawyer. The more people who are giving legal advice, there's a theoretical increase of risk. But the Lawyer Insurance Fund was comfortable that on a 2 model supervision that wouldn't be a problem. Designated paralegals and paralegals still continue to be covered. The lawyer essentially is covered for their actions under the existing insurance model. If the model after 2 years would be expanded to something larger, then who knows? That obviously would have to get revisited. We'd have to go back to the Lawyer Insurance Fund and say, if we completely remove that cap, how does that change things? But A, that's a discussion for a future date, and B, as Art said, if the day comes down the road where there was a direct credentialing and regulation of paralegals, my guess is that would involve an insurance structure for them as well.
Great. Thank you. Are there any more questions in the room here? Sure, yeah.
With regards to discovery and mediation, is that something that the Law Society is looking at for designated paralegals?
Right now, it is exactly as it is, and so it doesn't extend to that. I think when we get through the evaluation process and we're talking to the courts and it goes into something larger, those types of issues would come up. I know Art was asking that very question about discoveries a while back, but right now, no. And I think right now what we're really looking at is seeing the story play out as it is over that 2-year period and doing an assessment of it, rather than trying to tinker and modify with what we've got over the next few years.
Doug, I missed that question. Could you just repeat the question?
Sorry, it was whether or not the designated paralegals were able to do discoveries, and I can't remember what the second, and mediation. No. Mediation, what you have to recognize is that with the paralegal, you are operating as someone under the supervision of a lawyer. If you were to leave your employment of your lawyer and you were to be a mediator, then you'd be subject to whatever the appropriate rules for mediation are. We have procedures for lawyers who are acting as family law mediators and requirements for them. But because paralegals aren't members of the Law Society, those things don't apply. So my baseline would be, if I was a lawyer, I would not be allowing my designated paralegal to be running mediations.
Great. Thanks, Doug. Art and Doug, I just wanted to read a couple of comments that people have made. Nancy's wanted me to thank both of you for offering such clear answers to all your questions and for your support for designated paralegals going forward. Diane has also said, I would like to pass on Doug and Art. They're going into the session. I was oblivious on the whole idea, but now I'm... Anyway, she's thanking you. I don't know what she's saying.
It all makes perfect sense.
Diane
Diane
now knows everything. So there's a lot of comments here, people thanking you for the wonderful wonderful talk. And Marianne, Monica Burns wants to say hi to you. So anyways, on that, it's a little after 1, so we're going to wrap things up. So I'd like to, on behalf of the BC Paralegal Association, thank Art and Doug for their time, for coming here today. I think everyone in the room can agree with me that this is really informative, and I think paralegals, our association anyway, really wanted to know about this. So thank you very, very much. I'd also like to take this opportunity to thank the CLEBC. This was our first live webinar, and I think it went rather well. A couple of glitches here and there, but I think we did well. So if anyone has any comments or questions, they can email me directly. And
I have one last comment.
Yes, absolutely.
And that is to thank Rose Singh. Rose, you had a tough job. No one trained you to do what you did. You did amazing amazingly well
Thank you, Art.
bringing that skill to the subject. Rose is on our Law Society Access to Justice Committee, and it's that committee that developed the paralegal program under one of its working committees. Marianne Reinhardt is also on that, and we felt it was important that if this paralegal project is going to get the support it needs, what better way to do it than have two very well-respected people in the profession be part of the Law Society group. And so we are totally committed to this program. We work together. Doug knows this so well, and he's truly happy to take questions that you have. And I'm just so impressed, Doug, how well you managed to convey very good and sometimes difficult questions with such wonderful answers. So it's our treat and our pleasure to be here, and we're grateful for the opportunity. We are all in this together. Thank you very much.
Thank you. Thank you.